Let's focus for a minute on the concept of breach of contract. A breach is defined as an unexcused failure by a party to a contract to perform their contractual duties. For example, a buyer or seller may back out of a real estate transaction during the escrow period. However, when all contingencies have been met and an offer has been accepted, backing out of the contract would be considered a breach. There are two types: material and immaterial. A material breach is one that causes harm to another party in the contract. When there's a material breach, the non-breaching parties are allowed to seek remedies. Immaterial breaches don't damage the contract or cause significant harm to the other parties. Whether remedies are available in an immaterial breach depends on the amount of harm caused. Before we can discuss responses to a breach of contract, we have to look at a concept in contract law known as privity. Privity refers to the relationship between parties in the contract. For this reason, only a party to the contract may bring suit against another party for breach. For example, Adam rents an apartment in a building owned by Linda. Linda recently purchased the apartment building from Edward, and as a part of the purchase agreement, Edward agreed to make certain repairs on Adam's unit. Unfortunately, Adam finds that there is still significant damage in his apartment. When Adam talks to Linda, she's surprised, since Edward was contractually required to repair that apartment. In this case, Adam can't sue Edward for failing to make the repairs. Adam and Edward weren't parties to the same contract and were never in privity of contract with each other. On the other hand, Linda and Edward did form a contractual agreement. This means they were in privity of contract. As such, they're the only parties who have legal standing to file lawsuits related to the contract. There are several exceptions in the doctrine of privity, and two apply to real estate contracts. Those are agency and restrictive covenants. Remember that with agency, when an agent gets involved in a contract with a third party on their principal's behalf, the principal retains the right to enforce the contract against the third party. At the same time, the third party is still allowed to enforce the contract against the principal. This goes back to one of the foundational concepts of agency. The person acting through an agent is considered to be acting themselves. Having an agent form a contract with a third party doesn't shield the principal or the third party from responsibility if either breaches the contract. On the other hand, a restrictive covenant is an agreement in which the buyers of real estate agree to certain rules regarding the property. In most cases, restrictive covenants are attached to the properties located in subdivisions, condominiums, or some type of other group living situation. A restrictive covenant may require the property owners to keep the front lawn well trimmed, or may define a specific exterior color that can be used for outbuildings. Failing to abide by restrictive covenants can result in legal action being taken against the owner. Restrictive covenants are transferable from one party to another. They usually run with the land. A restrictive covenant that runs with the land would affect whoever owns the property. For example, Terry purchases a newly built home in a subdivision. The contract for purchase states that the house will be subject to the subdivision's restrictive covenants, which were established by the local homeowners association. Later, Terry sells the home to Brenda. Assuming the restrictive covenants run with the land, Brenda will be required to comply with those same rules. This is important because even though Brenda wasn't in privity of the original contract with the HOA still has the right to legal remedies set forth in the original contract should Brenda violate the restrictive covenants. When a breach of contract occurs, the breaching party may be able to employ defenses to protect themselves from legal consequences. The law recognizes a number of defenses that can protect a party from liability related to a breach. These defenses may lessen or completely prevent liability from damages. Common defenses to a breach of contract include impracticability or impossibility, failure to meet a condition precedent, illegality, coercion, or duress, mistake, fraud, and repudiation of the contract by the other party. Remedies are what the courts provide as compensation or as settlement of the dispute when a breach of contract occurs. For example, Grace is buying a house. When she makes an offer on the house, she provides an earnest money deposit. The offer is accepted along with the earnest money deposit, and a purchase contract is formed. A few weeks later, she backs out of the purchase even though all of the contingencies have been met. The remedy in this case is the earnest money deposit. As compensation for the breach of purchase contract, the earnest money may be forfeited to the seller. This is, of course, a greatly oversimplified example. Any discussion of remedies in this class is only intended to be a general discussion of the topic.